I'm here this morning to speak about some important history as to the contents of Canada's Charter of Rights. Specifically, I'm going to talk about how it is that property rights, which were part of the Canadian Bill of Rights, did not make their way into the Charter when it was adopted as part of the 1982 constitutional patriation. This was unlike almost everything else in the Bill of Rights, which did go into the Charter and even got expanded. And I'm going to talk about how it is that Canada ended up a constitutional outlier amongst liberal democracies in not having a property rights clause in its written Bill of Rights, something which virtually every other liberal democracy with a written Bill of Rights does. So this is important history about the 1982 constitutional patriation, but it's also important to us in present-day 2013. The old line about those who don't know their history are condemned to repeat it has an analog here. Those who don't know their history are condemned to keep living it. So long as we don't understand the history on property rights, we're condemned to not having secure protection of property rights. After talking about the history, I'm going to talk about some of its implications in terms of securing greater property rights protections today. I'm grateful to the organizers for seeing the relevance of this work and inviting me to speak on it this morning. Scott Reed and Randy Hillier are pursuing a very important project, and Matt Buffton and the Institute for Liberal Studies' organization of this conference provide an important venue for discussion. I'll just also note that I have a lengthier paper on this morning's topic, 40 pages or so, co-authored with Laurel Binion, one of my two research assistants, along the other being Michelle Lang, who are here with me here at the conference, and from both of whom you'll have a chance to hear further on our panel on legal issues related to property rights entrenchment first thing tomorrow morning, so an early advertisement for that panel. Our paper on this morning's topic is currently under consideration at an academic journal, which has asked us not to have posted copies anywhere at the present time so as to respect the blind review process. But as soon as circumstances change on that, I'd happily make available copies of that paper or a link to the conference organizers if they care to post that, and you'd be able to read more if you wish. I'll also note that though I'm drawing on the paper in my remarks, I'm presenting my own perspective, and in the context of a co-authored paper, we wouldn't necessarily say all the same things about it in the remarks that we would make. I leave enforcement of thought uniformity to the left-wing social engineers, and I'll give my perspective on some thoughts from the paper. So the history on the exclusion of property rights from the Charter is not one simple story. Some are instinctively inclined to blame Pierre Trudeau, given his central role in relation to the Charter and the 1982 constitutional patriation. Well, we can blame Trudeau for a lot of things, and it's always good to think up more to blame him for, and Bob Plamondon's new book gives us some perspectives on that. But we can't really blame him for this one. Trudeau had, of course, long advocated for a written Bill of Rights, but his drafts actually all started with property rights included. Property rights kept getting removed from his texts, and he might have acquiesced in this in light of the overall political calculations, but he was potentially ready to include them. I'm going to speak today rather to first a certain legal intellectual climate in the late 1970s, early 1980s, immediately preceding the adoption of the Charter, and second, to some provincial perspectives and chance events during the negotiation processes that fundamentally shaped the Charter on this point. A third aspect to the claims in the paper that I've referenced is that there were legal misapprehensions at stake, and you'll hear more about this aspect implicitly on the panel tomorrow, where there's going to be some discussion of the actual legal consequences of different types of property rights clauses. But my story this morning is that a combination of legal intellectual climate and some of the provincial premier's perspectives, along with the dynamics of the negotiation processes, led to the exclusion of property rights. So it's an intriguing human history of intellectual forces, but also of smoky back rooms and even some secret hotel rendezvous. And I'll name some names later, just wait for it. But this history also has some very important lessons for today for any of us who care about securing property rights protections. The constitutional negotiations leading up to 1982 did not take place in some magic place outside of history and politics. Pierre Trudeau never made a trip up Mount Sinai to bring the Charter down. The 1982 constitutional negotiations were, like any negotiations, riddled with human tendencies and human frailties. There was no revolutionary moment of inspiration, but rather a constitutional text that emerged out of a process and that was thus fundamentally affected by things that affected that process, including the ideas of the time. Had the Charter been adopted at some other moment in time, I would claim, its contents might well have been different. So there's a historically bounded nature of the Canadian constitutional text, and I'm going to suggest that that's clear actually in various ways in the Charter. I'll mention just a couple of other examples briefly. Many of the provisions in the Charter, such as its language rights provisions, are not embodiments of some universal set of rights in other human rights instruments, but rather of a particular national narrative whose proponents got them included at that moment in time. The Section 33 Notwithstanding Clause is a relatively unique piece of the Canadian Charter that grew out of a historically important role of parliamentary sovereignty within Canadian traditions and was advocated by premiers who had grown in those traditions. Particular rights clauses even, like Section 15 sub 2 related to affirmative action, reflected thoughts of the time that are not necessarily permanent thoughts. There's been a real shift in thinking, for example, on affirmative action in the United States from 1982 to 2013, if you look both at polling data and at what's said in the case law. But in Canada, that got into an entrenched constitutional text through the negotiation processes based on the thinking at the time. The omission of property rights, I'll suggest, is an example of the same sort of phenomenon. The largest prior article to examine this omission, one by Alexander Alvaro, writing in the Canadian Journal of Political Science a number of years back, explains this omission in terms of what Alvaro called a shift from a property-focused philosophy to a democratic-focused philosophy. As a believer in property rights, I partly reject those categories because I would consider property rights quite fundamental within a democratic system, so I wouldn't draw that dichotomy in that way. But we can still appreciate the way in which Alvaro puts emphasis on the intellectual currents leading up to 1982. I want to cast a different nuance on those currents in relation to property rights. Beginning in the early 1970s, there was a real rethinking going on amongst American political theorists who were trying to find ways, in many cases, to justify the expansion of the welfare state in the United States. John Rawls's 1971 A Theory of Justice, well known to many people, of course, became an enormously influential work that fit those intellectual currents of the era. So there are more complicated things to be said about it, but one of the things that Rawls did in his work was to deprioritize economic liberties that had been part of the classical liberal rights tradition. And in the paper, we actually traced through how this shifted in different editions of A Theory of Justice, and maybe received less notice than it may have deserved, but there is that kind of element there to what Rawls had done. Classical liberal rights to property that had been recognized for centuries and longer lost out in certain political ways in the maelstrom of the 1960s, and the leading political theorists who embodied the spirit of the 60s into their works in the 1970s. Rawls's work actually captured most liberal theorists, partly because of its own force, but partly because of another intellectual development that occurred shortly thereafter. In 1974, Robert Nozick published his classic work, Anarchy, State, and Utopia, which offered a philosophically rigorous libertarian alternative. Although that work has been very influential with many people and offers a very rigorous argument for its case, it wasn't at the time set to take hold with broader audiences at that time. It's received more attraction since in a different political era. As detailed in John Tomasi's recent and very insightful book, Free Market Fairness, the starker libertarianism of Nozick's book actually gave Rawls's advocates somebody to attack and a way to demonize the opposition as all necessarily committed to all that to which Nozick was. And thus many more moderate liberals got called into Rawls's liberalism as the supposed heir to classical liberalism, despite the radical changes that had actually been made within it to the traditions of classical liberalism. Now, I'm not going to stand here and say that the constitutional drafters in 1982 were sitting there and saying, well, what would Rawls put in the Constitution and what would he leave out? The intellectual influence is not quite so direct. But the spread of Rawls's ideas through many different thinkers, from many of whom some of the leading constitutional drafters studied during their studies, and who all exerted a general hold on the left liberal imagination of the time, meant that these ideas had an impact. It was a time-bound one, but no less real for that. Those who were defenders of property rights were, putting it frankly, losing the intellectual battles in the 1970s, if setting up the case better for in the 1980s. And this set things up differently for a constitution enacted in 1982 than one that would have been enacted at another particular moment in history. Well, that's a high theory sort of explanation of some background to 1982. But 1982 certainly wasn't all about high theory, and at the outset I promised to tell you also some tales of smoky backrooms and secret hotel rendezvous, so we need to turn to those. There was no short road to 1982. It was the culmination of 14 prior rounds of constitutional negotiation, aimed at achieving an amending formula for the Canadian Constitution that would be based in Canada rather than in the British Imperial Parliament, where it was previously necessary to go in order to achieve amendments to the Canadian Constitution. And this was done on several occasions. There were various smaller amendments made, but this had seemed unseemly for decades, that an independent country would have to go off to the British Imperial Parliament to seek an amendment to its own constitution. So there have been many different attempts at this. When Trudeau became involved, he began making a Charter of Rights part of what he would seek in the context of a constitutional patriation. Well, property rights were part of the charter that Trudeau first proposed in 1968. They fell out of the document by the time of the Victoria Charter in the early 1970s. I'm not going to trace that history. That document didn't proceed anyway. It came close to succeeding, but there were various dimensions to it, and the story may not be fundamentally different than how they came out later. The charter that Trudeau proposed in 1978 similarly contained property rights once again, as did the text that was put forward again in 1980. Each time the provinces raised concerns. Provincial opposition centered around concern about the potential effects that property rights would have on their abilities to legislate under the provincial jurisdictional power of property and civil rights. The perception of many provinces was that the Charter's impact fell unduly on the provinces as opposed to on the federal government, and they saw it in many ways as a loss of power for the provinces. At the time of committee discussions in 1981, and I'll come back to these committee discussions in more detail in a moment, both Saskatchewan and Quebec had recently expropriated and nationalized some of their industries, and they worried about whether a property rights clause would have let them do that. Prince Edward Island had passed legislation limiting how much land non-residents could own on the island, and they worried about whether they could have done that had there been a property rights protection. And that might be the point of having property rights protection, but I'll leave that aside. Alberta had property rights protection in its provincial Bill of Rights, and even Alberta went and opposed the inclusion of property rights in the Charter, saying that it strongly believed that property should be dealt with only by the provinces. Given the worries by the provinces, when the Liberals released a federal discussion draft of the Charter in August 1980, so this is shortly after the 1980 draft that I referenced a moment ago. By August 1980, property rights were no longer present in the draft of the Charter. At this time, in the wake of various ongoing discussions and controversies about the Charter, the federal government then established a special joint committee of the Senate and House of Commons that would meet through the early months of 1981 to hear various submissions on the detailed contents of the Charter. So that committee was meeting in the context of a pending patriation reference, in which the Supreme Court of Canada was being asked whether the federal government had the ability to unilaterally patriate the Constitution without the support of the provinces, which had become Trudeau's preferred tact, given the opposition from the provinces. The Supreme Court of Canada would ultimately release its judgment in that case in September of 1981, but obviously everyone knew that it was coming. Its looming presence was already felt. So the federal government challenged in that case on the basis, or one of the bases on which it was challenged, was that its modifications were interfering with provincial jurisdiction under the 1867 Constitution. It had to be sensitive to worries that it was interfering with provincial jurisdiction in the discussion that would take place with the provinces. And in order to assure the overall legitimacy of patriation, the federal government also wanted cross-party support, rather than this being seen as only an instrument of the Liberal Party. The Conservatives were potentially opposed to the Charter outright, which drove the Liberals even more and more to want NDP support in order to have at least some cross-party support, with the hope eventually of having Conservative support as well. NDP support was in turn contingent on provincial approval, the way the NDP had set things up, especially from Saskatchewan's then NDP government, which was the only one in the country. Some have argued about the significance generally of the Joint Committee hearings of 1981, the Special Joint Committee of the Senate and House of Commons. In particular, those that challenge the significance of these committee hearings say that since the patriation reference released later in the year did in fact say that provincial support was necessary, then only the later negotiations between the provinces actually count for anything. But the Joint Committee still did establish the bulk of the text of the Charter. There were significant amendments later on, including the addition of the notwithstanding clause. But in many ways, the Joint Committee proceedings represent the official drafting history of the Charter. And so this is all very complicated, but this is the history of Canada's Constitution. The Joint Committee received a number of submissions in favor of property rights from various organizations. But the Liberals themselves would not have moved on the issue out of concern at reaction to this from the provinces. However, on Thursday, January the 22nd, 1981, the Liberals were presented with an opportunity that they were ready to embrace. Mr. Crombie, speaking for the Conservatives, and there's a full record of these special Joint Committee hearings that's available and readable. Mr. Crombie, speaking for the Conservatives, proposed an amendment to Section 2 of the Charter, which is the section containing the fundamental freedoms of religion and expression and assembly and association. He proposed an amendment to Section 2 that would have added a Section 2E on property rights. The Conservatives had, during the discussions, also previously indicated a readiness to support the addition of property rights in Section 7 of the Charter, which is the section that's life, liberty, and security of the person. The Liberals on the committee preferred to locate property rights in Section 7 of the Charter rather than Section 2 for a variety of reasons. So Solicitor General Kaplan, sitting in that day as Minister of Justice for Mr. Chrétien, who was in hospital at the time, told Mr. Crombie that if the Conservatives would withdraw property rights from their proposal on Section 2, there were other proposed amendments there, then the government would agree to support a Conservative amendment to add property rights to Section 7 in the subsequent days. In doing so, the Liberals wanted to be seen as having only agreed to let property rights into the Charter under some pressure, and not as having proposed them, thinking that that was the better political calculation. And there's also some evidence that they had a plan of trying to draw the Conservatives more generally into being ready to support the Charter once they got some content in it that they had proposed. Well, on Friday, January 23rd, the next day, Mr. Crombie put forth the amendment on Section 7 as had been planned and has been discussed. The amendment would have added protection of property rights to Section 7, so the section on life, liberty, and security of the person. This proposed protection was intended to protect property from being taken away without legal means and or without a fair hearing. It was a right that would have applied to anyone acting legally in Canada, including corporations. And there was a phrasing of Section 7 contemplated at the time, not in terms of principles of fundamental justice, which has become a term that led to all kinds of interpretation through the courts since, but in terms of principles of natural justice that would have limited the circumstances in which the courts would have been free to interpret the provision. So it was intended to be a relatively restrained protection of property rights, but including them along with fundamental values like life, liberty, and security of the person. The NDP proposed an amendment that would have applied Section 7 only to individuals instead of to everyone, in order to restrict it to natural persons rather than to corporations, but that was rejected. So this proposal seemed very close to passing, and Friday, January 23rd, 1981, could have changed a lot of things about the text of the Charter on this issue then. The Liberal Member of Parliament, Mr. Lapierre, affirmed that property rights are intrinsic to Canadian society, and he declared that the government was ready to support the Conservative amendment. But the NDP Member of Parliament, Mr. Robinson, objected to the inclusion of property rights in the Charter and said this would necessarily infringe upon provincial jurisdiction, drawing upon the argument that the provinces had been making. He argued that since the passage of the constitutional package would require the consensus of the provinces, rejecting the Trudeau view that it was going to be possible unilaterally, he said that property rights should not be included. He also argued that including property rights in the Charter would be the first instance of protection for so-called economic rights, and if property were to be protected, then it would make sense to include other social and economic rights as well, such as the right to a clean environment, that he presumably would have added into the text the same day. This argument no doubt traded upon a certain ambiguity in the term economic rights, on the scope of which there are differing views. But that very ambiguity made it an effective way of running some interference on the proposal that others could then build upon. Mr. Nystrom, also an NDP Member of Parliament, pointed out that this was the first formal motion for the inclusion of property rights, which seems to have ignored the motion of the previous day, but requested that the committee delay the vote on the property rights clause in order to have a chance to consult further, including with provincial governments, and to consider what other economic rights should be included in the Charter if property rights were going to be included. This request angered the Liberal Mr. Lapierre, who said the possibility of including property rights had been discussed many times, and who asserted that the NDP, just as the Liberals and Conservatives, had had ample time to consider the issue, and Mr. Lapierre initially said that the amendment should be voted on immediately. But in the end, Mr. Nystrom's request was honoured, and the vote was postponed until the Monday, that having been the Friday. So then here we can add some pivotal events of a weekend. They're challenging to unravel, but they would appear to have impacted on the text of the Charter that went forward from the Joint Committee. Over that weekend, seemingly on the Sunday, Mr. Broadbent, leader of the NDP at the time, told the government that if they supported the Conservatives' property amendment, then the federal NDP would no longer back the overall constitutional package. So there's some pretty tough negotiation going on. Mr. Broadbent claimed to sympathize with the provinces, and in particular with Saskatchewan, which was the only province with an NDP government at the time, and their fears that protecting property rights might prevent the government from nationalizing industries or from enacting laws regulating ownership of land. Again, probably the point of property rights. But Broadbent wasn't the only actor at work. The Liberal government also received pressure directly from the government of Saskatchewan that weekend. On the Saturday, January the 24th, there had been a meeting at the Four Seasons Hotel in Toronto, the place where the NDP presumably meets rather than the Super 8. At the meeting, Attorney General Roy Romano of Saskatchewan informed the Liberals that Saskatchewan could not accept a charter that contained property rights out of concern that property protection would limit Saskatchewan's ability to control foreign or absentee ownership of farmland, and a general desire not to extend the scope of constitutionally protected rights. And to be entirely fair, Saskatchewan's Premier Alan Blakeney was actually opposed to having an entrenched charter at all. So this was seen as just one additional thing in the charter that would further constrain the provinces. Well, apparently, partly in order to ensure that this rights protection wouldn't be included in the charter, Romanow also entered Saskatchewan into a larger deal with the federal government, whereby Saskatchewan would agree to support the federal constitutional package, including acquiescing to the charter, against which they had actually been raising concerns in general, conditionally on the inclusion of a natural resources clause into the constitutional amendments, which was eventually enacted in 92A, but with longer discussion around that. Conditional also on property rights being dropped, and conditional on Canada obtaining Saskatchewan's consent to any further changes that would be made to the text of the charter at the Joint Committee. So a sort of bilateral agreement between the provincial government and the federal government. The threats from the federal and NDP forces might have been independently sufficient to put to rest the property rights provision. It's difficult to interpret just what went on. We have other things to add into the story. In addition to meetings at Toronto's Four Seasons Hotel, we'll have some phone calls from Hawaii coming up on the Monday as well. On Monday, January the 26th, 1981, the Conservatives put forward their amendment to include property rights in Section 7, presumably not knowing all of the discussion that had taken place over the weekend, although some of it had been reported in the media in terms of Mr. Broadbent's statement. In the face of the threats from the NDP, and because of the bilateral deal with Saskatchewan, Mr. Chrétien, now back from the hospital and having resumed his position on the committee, refused to back the Section 7 amendment. Premier Blakeney of Saskatchewan actually ended up cancelling Saskatchewan's bilateral deal with the federal government that same afternoon, out of concern that he had that Trudeau's plans concerning the Constitution were a little bit too much of a moving target. He might have done so after events had already occurred at the committee, because Premier Blakeney was in Hawaii at the time, and the time zone difference may well have had that implication. But if the Broadbent statement was enough on its own, the detail of when Blakeney withdrew from this agreement may not be crucial. The reality, in any case, is that the combined effects of several NDP politicians' actions had delayed a vote on a property rights provision that could have been voted on the Friday, from when it would have presumably succeeded at that point, and cast enough problems in its way so that it failed on the Monday all over the course of a weekend. That wasn't the only or last chance to add a property rights provision, but in the end, a complex negotiation process in the context of ongoing provincial concerns had the impact that including property rights in the Charter became too risky for the federal Liberals if they had been willing to do it. Trudeau was ready, in essence, to negotiate away property rights, and at the late 1981 meetings with the premiers, there was no attempt to put them back in. There were, of course, subsequent post-charter attempts to add property rights to the Canadian Constitution at various stages. British Columbia had a debate in the provincial legislature in 1983 where they were interested in pursuing this. There was actually a vote in principle in favor of the idea in the Federal House of Commons in 1988. But that didn't go anywhere in the end. And there have been other occasions where the idea has at least been raised. It's remained on the minds of many during constitutional reform initiatives. But at the time of the negotiation of the Charlottetown Accord, in the early 1990s, following the death of Meech Lake, property rights were raised, but the ultimate accord recorded them as one of the areas on which there had been a consensus not to proceed as part of the Charlottetown Accord. And so they weren't even proposed ultimately as part of that. And of course, the Charlottetown Accord didn't go anywhere in any event. So there's a longer narrative to the exclusion of property rights from the Charter, with, I would say, a number of chance factors along the way. It's conceivable that if some of those factors had played out differently, there might have been a different outcome. So arguably the legal intellectual culture on property rights preconditioned many not to support them, and made them a tradable commodity, as it were, facilitating some of the particular negotiation processes that followed. That speaks to contingency of the time period at which the Charter was adopted. And as I say, had it been adopted in a different year, in a slightly different time period, maybe things would have been different. I've added on also the contingency of the particular negotiation processes that went on, where a small third party successfully amplified its effects so as to keep property rights out, despite at least notional support for them from two parties that represented at the time the vast majority of Canadian voters. A third factor, which I won't explore at length today, but I leave to some extent for tomorrow morning's panel, was a set of ongoing, and I'll suggest mistaken assumptions about the legal effects a property rights clause would have had that raised these concerns for some of the provinces. And I would suggest that some of those concerns were larger than they needed to be. But what I've said already points to some extremely important lessons coming from the history for today. First, and it's a point to which I'll return, there's nothing that needs to remain fixed about the exclusion of property rights from the Charter. The exclusion was a decision at a particular moment in time, affected by the intellectual climate prevailing at a certain point in time, and by particular negotiations that went on. Adding something to the Constitution today is certainly tougher than it would have been to add it at the time it was under negotiation in 1982, or leading up to 1982. But there's no ongoing mandate in the Charter that precludes attempts to add property rights into the Charter. Second, intellectual climate matters. On this issue, or on others that matter to the people in this room, it's important both to mount popular campaigns, but also to have the winning arguments, the intellectual firepower that makes those campaigns resonate in other circles. I don't say that in any elite sense of calling for these kinds of intellectual arguments, but I say it simply in the sense that ideas matter, and the power to communicate those ideas effectively also matters. The media are not always a sympathetic audience for classical liberal ideals, if there's an understatement, but they can be won over. Having an array of think tanks supportive of classical liberal ideals matters. Having the Institute for Liberal Studies organizing this conference each year matters. Having each of you in attendance here at the conference, and having each of you tell a number of friends about it to go watch the video, and if each of them goes and watches the videos, that matters. I'm looking forward to learning lots from the other speakers at the conference and being able to go back and talk about the ideas from the conference, and I hope it's something each and every one of you will do also. That said, third, in crass political terms, at the point at which a certain constitutional development with which you disagree becomes verging on inevitable, there's also value in being partly on side with the development, and thus, for example, helping to shape a constitutional text in balanced ways, rather than trying simply to fight that constitutional text outright. Many property rights supporters were at the time leading up to 1982 fighting the Charter overall. They were fighting for their ideals, and you can't fault them for that. But in the process, the text of the Charter became reshaped in part by the NDP in ways that undermined the traditional balance of classical liberal ideals on matters like property rights. It's not always an easy point, and it always requires difficult decisions, but sometimes idealism is best maintained through pragmatism. Fourth, political coordination matters, and we see that lesson in this history as well. Whether it's achieved in a totally organized way or not, because we don't know all of the connections that did or didn't go on. Over the course of the crucial January 1981 weekend that I described earlier, and I described as crucial because that's the moment where you can say property rights could have been in the text that was going to go forward, and they didn't get in there. Well, over that weekend, some politicians achieved effects far beyond the force of the numbers that had supported that party, through actions that coordinated well in keeping property rights out of the Charter text that went forward. In seeking a property rights amendment today, it's important to draw on those lessons to ensure that it moves forward in politically astute ways that draw upon all the expertise available on matters like the text, ways that achieve effective political coordination so that it's a winning cause and not a setback to the cause. Fifth, there's reason for hope. Property rights have a proud tradition and are part of the fundamental ethos of liberal democratic states in general. Canada's failure to offer them constitutional protection makes it an outlier state in certain respects, with a history behind that, but that can be changed. There's nothing magical about the text of the Charter on this point. The fact that that text is historically time-bound in some ways makes it entirely legitimate to keep discussing the text. I'll open up to questions in a moment, but building on this point, I just want to leave you with one last thought in closing. And that's simply that the chance factors that contributed to it and the backroom deals of politicians 30 years ago simply shouldn't stop us today from fighting for the freedoms that they forgot.